Yes, Mr. Chairman, can you hear us?
Okay, thank you.
This regular meeting of the Montana Public Service Commission is now in session. The time is 9:30 a.m. It is the 1st of February, 2022. We are convened in the Bollinger Room in the offices of the Montana Public Service Commission. All four commissioners, Commissioner O'Donnell, Commissioner Pinocci, myself, Vice Chair Johnson, Commissioner Fielder are in the Bollinger Room. Chair Brown is participating remotely. So we have all five commissioners participating. If you would all rise, please, and join in the Pledge of Allegiance. And Commissioner Fielder, would you lead us, please?
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I am told we have no public comment. Is that still the case? Any public commenters in the audience? There are none, so we will proceed with the agenda, beginning with the action items. First, approval of minutes from the previous meeting. Is there a motion? It has been moved. Is there a second? Been moved and seconded, and we approve those minutes. Is there any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Aye. Opposed, no. Motion carries unanimously. Second, Mr. Rosequist with a request for out-of-state staff travel.
Good morning, Mr. Chairman and Commissioners. Staff requests approval for Brooke Umstead to travel to San Diego, California, May 8th through the 13th, 2022, to attend the National Association of Regulatory Utility Commissioners Western Rate School. You'll recall that staff applied for and received a $1,000 scholarship towards attendance at the NARUC Rate School last fall. Staff wasn't able to use that. A former staff member applied for it, but NARUC has offered to allow us to keep that scholarship and apply it to another new analyst. And I think the timing of this course is particularly good given the expected filing of Northwestern's rate case in June. And we've estimated an approximate cost after accounting for the scholarship of $3,000 for the travel. And I recommend approval, Mr. Chairman.
Thank you, Mr. Rosequist. Is there a motion? Commissioner Fielder.
Mr. Chairman, I move the commission approve staff travel for this purpose.
Been moved and seconded that we approve staff recommendation. Is there discussion? None. Call the question. All those in favor signify by saying aye.
Aye.
Opposed, no. Motion carries unanimously. Thank you, Mr. Rosequist. Moving on now to work session items in docket 202105-073. Mr. Duncan, Mr. Hamilton. Mr. Hamilton, you going to lead us? Thank you.
All right, thank you, Mr. Chairman and Commissioners. This particular work session concerns the North Central Montana Regional Water Authority, which is a mouthful, and the complaint filed by the town of Keevan against the authority. Staff circulated a memorandum on the motion to dismiss, which is currently pending, to advise the commission on how to deal with some of the issues raised in that motion to dismiss, in particular, town of Keevan's argument that the commission lacks authority to dismiss the complaint at this stage. It also discusses what staff believes is an important opportunity for the parties to provide supplemental briefing on a question of law. And that question of law concerns whether wastewater and water districts and municipalities, which are both exempt from the commission's regulation under the definition of public utility, should be able to exercise that privilege, if it is a privilege of exemption, jointly through the authority. And this requires the commission to consider for the first time a question of law that it has not previously addressed, and that is the effect of the Regional Water and Wastewater Authority Act. That act was amended most recently in 2013. In the legislative history for that amendment, the sponsor of the amendment to the act, Greg Jurgensen, who was then a senator and is of course a former member of this commission, provided some testimony which suggests that the legislature thought that the authorities would be exempt from commission regulation in the same manner as wastewater districts are under the definition of public utility, as water districts are, and as municipalities are. So I think it's important before the commission proceeds to hold a hearing in this matter for the parties to provide supplemental legal briefing on that particular question, because it could be dispositive and it could negate the need to hold a hearing in this matter because it would be beyond the commission's jurisdiction. So with that brief introduction, I'd be happy to answer any questions that the commissioners may have, but in summary, the recommendation from staff here is to direct the parties to address this question through supplemental briefing and to suspend the procedural schedule in this matter, including the hearing date, so that we do not end up having parties waste resources on a hearing that may not be necessary.
Chair would entertain a motion at this time. Commissioner Pronocci.
Thank you, Mr. Chairman. I would like to move that we support staff recommendations, Mr. Chairman.
Thank you, Commissioner Pronocci. Is there a second? Commissioner Fielder, seconds.
I second.
Is there discussion of the motion? Commissioner Pronocci.
If, say, even or someone doesn't like what's going to happen, they could encourage the legislation to introduce a bill to clear up where responsibility could lie or what our jurisdiction is. So I would be able to encourage people to turn to the legislation and work it out there. Does that sound like that would be a plan if somebody's not happy with how this works out?
Mr. Chairman, Commissioner Pronocci, that's correct. The legislature ultimately has the power to define both the scope of this commission's jurisdiction and of the processes and procedures that apply to regional water and wastewater authorities.
Thank you. I'll pass that along if I get any questions.
Thank you, Commissioner Pronocci. Is there further discussion in the motion? Chair Brown?
Just a clarifying question, Mr. Vice Chair first, and then I'll speak to the motion. So, Mr. Hamilton, just so I'm clear as to what we're voting on or considering at this point. So the motion is to suspend the procedural order in this matter and to direct staff to set a briefing schedule for the parties to address the following limited question, as I understand it. Are the statutory exemptions for water districts and municipal water systems in the definition of public utility privileges that may be jointly exercised through a regional water authority pursuant to MCA section 75-6305, correct?
Mr. Chairman, and Mr. Chairman, yes, that is correct.
Okay. Mr. Vice Chair, if I may.
Chair Brown, I'm sorry, my mic was off. Yes, Mr. Chairman.
I felt like I was out here in the ethosphere, speaking to myself. Mr. Vice Chair, the Montana Legislature passed the Regional Water and Wastewater Authority Act in 1999. As Mr. Hamilton stated, there was some discussion of this in the 2000 legislature, but for more than 2 decades since the adoption of that act, the Commission has not exercised authority over regional water authorities. Because the question of this Commission's jurisdiction over regional authorities is one of first impression, in my belief, the Commission really has no precedent to guide us in interpreting the act. One of the town of Keevan's primary arguments in opposition to the motion to dismiss concerns the lack of an exception to the statutory definition of quote public utility for regional authorities. As we are all aware, however, the statutory definition of public utility does contain exceptions for water districts and municipal utilities. Under the Regional Water and Wastewater Authority Act, water districts and municipal utilities are entitled to jointly exercise their powers and privileges by forming regional authorities. The way that Montana law is currently written, it is reasonable to ask the parties, in my belief, whether the statutory exemptions from this Commission's jurisdiction are the type of privileges that water districts and municipal utilities can jointly exercise through a regional authority. I must say that I have reviewed the statutory scheme in this matter. I've also reviewed the parties' briefing in this matter. And I do not believe that question, that statutory question, has squarely been answered to this point in any of the briefing. And while this is a question of law that the Commission could certainly answer on its own at this point in the proceedings, I believe it is best to ask the parties to address the statutory question and application and interpretation first to better guide us. I also believe it is prudent to suspend the procedural schedule so the parties do not have to invest substantial time and resources preparing for an evidentiary hearing that may ultimately be unnecessary. So for these reasons, I will support Commissioner Pinocchi's motion and staff's recommendation. Thank you, Mr. Vice Chair.
Thank you, Mr. Chairman. Is there further discussion? Commissioner Fielder.
Thank you, Mr. Chairman. Just a technical question for Mr. Hamilton. Is there a difference between suspending the procedural schedule and vacating it? Because I see the terminology vacation, not vacation, but vacating being used in the staff recommendation that's written before us.
Mr. Chairman, Commissioner Fielder, to my mind, in this circumstance, there's really not. As a practical matter, both would get us to the same ends where the obligations of the parties to file responses to the pre-hearing memoranda and to prepare for the hearing currently scheduled for March would be eliminated, and we would, under the circumstances, need to reset that hearing for a later date. So at this point, it would change the nature of the parties' obligations to prepare and focus on legal briefing rather than hearing preparation.
Thank you. And Mr. Chair, I understand that the motion is to adopt the staff recommendation as written in the staff memo, correct?
That is correct, Commissioner Fielder.
Thank you.
Commissioner O'Donnell.
Thank you. It would seem to me, without knowing exactly how lawyers proceed on things, that whatever, if this came to the commission after briefing on this and by the parties, and we made a decision that one of the parties, the aggrieved party, may ask for a secondary opinion from the Attorney General's office or from DOJ, it would seem to me to be useful to accelerate things along if we also asked for an opinion from the Attorney General's office on this issue. I think they're going to be asked for it anyway. We might as well include that in the beginning, I think. Mr. Chairman, is that would that be acceptable to the motion to add that on there? Or does that sound like a good idea, Mr. Hamilton?
Mr. Hamilton.
Mr. Vice Chairman and Commissioner O'Donnell, right now we have a contested case in front of us that'll proceed according to MAPA, the Montana Administrative Procedures Act. Pursuant to that act, a party must exhaust their administrative remedies in front of this body first. So if the commission makes a decision and the losing party, for the lack of a better word, feels that the decision is incorrect, they would first exhaust their remedy by filing a motion for reconsideration, which we're all familiar with. We deal with a lot of those. And then if they still believe that the commission is incorrect, they would petition for judicial review. And that way a district court would make the first determination of whether or not the legal conclusion rendered by this commission is correct. I don't believe that it would be necessary or appropriate to seek an opinion from the Attorney General's office or the Department of Justice on the legal interpretation of this statute. Since it is a question of law, it would be appropriate for a court to review that through MAPPA's procedures.
Mr. Chairman.
Commissioner O'Donnell, follow up.
Well, I'm just thinking that after they, do their opinions on each of the parties, then it would come to us. I just think for myself, it would be much easier to come to a decision if I had some information also from the Attorney General's office. If that is not allowed according to procedure, I fully understand the reason for process and procedure. I'm a lot more dedicated to getting answers more quickly than that allows. So that would help me in my decision making. I think, not having had this information in front of me, I would like to have that information. But if it's not possible, then I guess not.
Further comment, Mr. Hamilton?
Mr. Vice Chairman, thank you, Commissioner O'Donnell. I wouldn't necessarily agree with the premise that it allows a quicker determination of the facts here. It's common in administrative law for the agency to pass on their jurisdiction in the first place, to make that jurisdictional threshold question here. The Attorney General's office, under case law, under administrative precedent, would not be in a position to determine this agency's jurisdiction in the first instance. The opinion of the Attorney General, to the extent that one is rendered, would also be subject to review by a district court. It would always inevitably come to a district court if a party felt that the opinion was incorrect. So I don't know that that gets us any quicker to the final resolution of this legal question.
Mr. Vice Chair.
Chair Brown.
I would echo the comments of Mr. Hamilton on this. I would state that procedurally, this matter is before this agency who has the jurisdiction to make a determination on the application, interpretation of the statute at hand. It is more than appropriate that we make that statutory application and interpretation. I suspect the Attorney General's office, presented with a question of interpretation on this, understanding the factual situation and procedural situation that we find itself now, would decline in any event, saying this is a matter that is within the PSC to make a determination. And I echo what Mr. Hamilton says, that if one of the parties here too determines that our interpretation of the statutory framework that is applicable here is wrong, then the appropriate determination to declare what the law is will rest first with a district court and then perhaps with the Supreme Court. So I find Commissioner O'Donnell's suggestion to be not only beyond jurisdiction, but extraneous, Mr. Vice Chair.
Thank you, Mr. Chairman. Is there further comment? Further discussion? Commissioner O'Donnell.
Thank you, Mr. Chairman. Not to belabor, but I wasn't looking for determination by the Attorney General's office. It's something that would guide me, just another party, to interpreting things just as an advisory thing. As I understand that in the layman's use of the word opinion, it's different from the legal definition of what opinion is, that bearing some authority and weight to it. I just wanted some more input, not to pass it on to somebody else, but just to help me in my own decision making, Mr. Chairman.
Thank you, Commissioner O'Donnell. Further discussion? I just simply would make a couple of points. One, I would say that I have tremendous amount of confidence in the expertise that resides with our legal staff in this narrow area of regulatory law. And I think, frankly, the staff attorneys at the AG's office are forced by design to be far more generalists and don't have the kind of narrow expertise that we have here. So I'm eminently confident, Mr. Hamilton, Mr. Reed, in what legal will do for us in terms of analysis in this docket. Secondly, I just make this observation in terms of the motion specifically. It seems to me that this is not the first time in recent history that we've had parties come before us arguing issue A and asking us to decide issue B. I think that is not an acceptable approach, and that staff recommendation will cause the parties before us to actually argue the issue that they're asking us to make a decision on. So I certainly am supportive of the motion. Is there further discussion? Hearing none, call the question. All those in favor of the motion to approve staff recommendation signify by saying aye.
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 Opposed, no. Motion carries unanimously. Thank you very much, Mr. Hamilton. All right, moving on now to Northwestern Energy's docket 2021.11.132. Mr. Hamilton, you're back up.
Thank you again, Mr. Vice Chairman and members of the commission. This is the Northwestern Energy application for approval of the energy storage agreement for the Beartooth Battery Project, which will be built in Yellowstone County. The Montana law on pre-approval requires the commission to make a determination on whether the application is adequate within 45 days. That'll run out for us on February 4th. So it's important for the commission to consider the application and make a decision on its adequacy here today. Staff memorandum was circulated for the commissioner's review yesterday. We have received comments from MCC, which call into question the adequacy of the application. We also have responsive comments from Northwestern Energy. Staff's recommendation here is to find that the application is adequate, that it satisfies the elements outlined in our procedural rule, which is at 38.5.8228. I think that there is reasonable interpretations or multiple reasonable interpretations that can be made of our rule. What MCC has suggested as their interpretation is one reasonable way of looking at the rule. However, it is staff's recommendation that based on the plain language of the rule, it is better to find that the application is adequate at this point. We also recognize, however, that this is a unique docket, that this is the first time that the commission will make a determination on rate base, or including in rates, the costs of a battery storage facility. It raises novel questions of modeling for the commission to consider and for interveners to explore. And for that reason, staff also recommends that the commission extend by 90 days the deadline for determination, a final decision on this application. There are two different timelines that can apply to a pre-approval application under the law. One is 180 days and one is 270 days. As outlined in the staff memo, we believe that the more appropriate deadline for this particular application is the 270 days. So if the commission agrees with staff's recommendation, it would be adding 90 days on top of the 270 days that is outlined in statute. And that would be the deadline for the commission's final decision in this matter. Finally, staff has also identified 4 issues that we believe would be appropriate to have Northwestern address in the first instance as additional issues, and then for the interveners to address as they prepare their discovery and testimony of their own. So staff's recommendation also includes 4 issues to identify, to flag for the parties as items that need additional fact development at the early stage of this case so that we can still proceed with the timely resolution of the application. With that, I would pass it over to Gary Duncan from Regulatory here, who knows about the history of pre-approval, and in particular, the importance of these 4 additional issues far better than I can describe them. So of course, when Gary's done, I'd be happy to answer any questions that the commission may have.
Thank you, Mr. Hamilton. Mr. Duncan.
Mr. Chairman, Commissioners. Let me find that memo. Just briefly, the four issues that staff identified are that the testimony from Northwestern gives us the estimated cost of the ESA over 20 years as being $145 million, $130.5 million of that being fixed. That's based on the contract rates within the ESA. However, Northwestern also testifies that they will be purchasing power on the open market to charge the battery when market prices are low, that they will be then discharging the battery into the market if prices warrant it. They've also testified that there will be certain transmission costs. Oops, excuse me. There will be certain transmission costs associated with in doing so, but they made no estimate of those costs. So when you look at the gross costs associated with the ESA, staff think there's a hole there in that they haven't identified or made an estimate of those types of costs. Secondly, staff believes it's imperative that in a pre-approval of this sort that the commission has to find this in the public interest, and that one of the things that needs to be considered in the public interest is the impact on customer rates. And while Northwestern has given us an partial estimate of the total gross cost of the ESA, they have not given us an estimate of the impact on the PCAM. Northwestern is proposing to recover both the fixed and variable costs of the ESA through the PCAM. One can anticipate then that part of the purpose of the Beartooth battery would be to replacement of power purchases on the open market. They've not given us any estimate of how this might reduce the amount of power they're required to purchase. And again, they haven't given us any estimate of the amount of credits that would flow to the PCAM if they sell into the market. And again, they haven't given us any estimates of the purchase power costs. So we do not have any estimate of the net impact on the PCAM. And staff believes that's a crucial element to this. And a third item we talked briefly about is the PCAM is typically considered a fuel or supply and purchase power mechanism. It's a supply tracker. And typically what's tracked in supply trackers are variable costs that are significant, that can go up and down, that are somewhat out of the control of the utility. There are 2 pieces to the contract, the Beartooth battery ESA, and one is the fixed cost, which is $130.5 million over 20 years. We know what that cost is. It escalates at 2% a year, beginning in the first year. And one must question, I think, as to why that fixed cost would be recovered through the PCAM rather than perhaps through the generation revenue requirement. The generation revenue requirement contains the fixed costs for all of the other generation of Northwestern. For example, the CU4 fixed costs are in the generation revenue requirement. The fuel costs, the coal, are in the PCAM. Dave Gates fixed costs are in the generation revenue requirement. The fuel or the variable costs, the gas costs for Dave Gates, are in the PCAM. So here we have another instance where we know the fixed costs. What is not known, what could vary, is the variable cost. So there's some question as to why they proposed recovering all of this through the PCAM, and we believe that should be addressed. I would say that there is a difference regarding Beartooth battery in that those other assets I mentioned they do have assets, they do have a rate base. That's not the case with Beartooth Battery. So we have another instance where we have Basin Creek. Basin Creek also has a fixed cost and a variable cost component, both of which are recovered through the PCAM. So it's sort of a gray area, but we think it ought to be addressed. The PCAM is now up to something like $185 million a year, which is about 20% of the total revenues of Northwestern, and it just seems to be getting bigger and bigger over time. So, if the cost doesn't need to be in the PCAM, then I would question why it's in there. So we would like that addressed as some rationale as to why they have that in the PCAM. And the final question that they need to address, we think, is that in their capacity rate, the capacity rate is paying for the capacity. It's also paying for the provision of ancillary services, and ancillary services can be services provided through their FERC jurisdictional tariff, interstate services. And if they're provided through their OAT tariff, their open access transmission tariff, and they're recovering part of that cost from the FERC jurisdiction, then one would think there might be a possibility that part of that base cost needs to be allocated to the FERC jurisdiction and not recovered from Montana ratepayers. And they haven't mentioned anything at all about any possible FERC allocation for ancillary services. So those are the questions we came up with that we would like to see addressed. And, we could do that in discovery, but it would be, I think, better if they just addressed those questions up front.
Thank you, Mr. Duncan. Anything further, Mr. Hamilton?
No, Mr.
Right,
Vice
and I
Chairman.
know folks are ready to weigh in, but we're going to stick to the playbook, and we will open the floor to discussion as soon as we have a motion to discuss. Chair Brown.
Mr. Vice Chair, thank you. Mr. Vice Chair, thank you. So, colleagues, I move to one, find that Northwestern's application is adequate. Two, to clarify that the deadline for the commission's action is found within Montana Code annotated section 69-8-421 sub 4. To extend the deadline for the commission's final decision by 90 days, and to direct the parties in this matter to address the following issues, whether, outside of discovery, as mentioned by Mr. Duncan. A, what is the total gross cost of the ESA, including estimates of energy purchases and transmission costs? What is the estimated impact of the ESA on the net cost of the power costs and credit adjusters mechanism? What costs associated with the ESA, if any, should be recovered through the generation revenue requirement instead of the PCAM, and why? And should any part of the value of ancillary services be allocated to FERC jurisdictional customers? And if so, why and how? Mr. Vice Chair.
Thank you, Mr. Chairman, and I will second that motion. Now, Mr. Chairman, if you'd like to open with a discussion of your motion.
Thank you, Mr. Vice Chair. I have read the briefing submitted in this matter, both from MCC and Northwestern Energy. I think Mr. Duncan covered well the number of questions that are still outstanding from the initial filing made by Northwestern for this in its pre-approval application. Even so, I believe that the outstanding questions can be addressed by the parties by allowing this proceeding to move forward. We have several mechanisms for gleaning the information that the commission needs to make a final determination in this matter, not the least of which is those questions that I have directed Northwest Energy to answer as part of my motion. And then, of course, we do have extended and wide discovery powers. I believe the best path forward is to allow the matter to move forward so that we can determine the merits of the pre-approval process, Mr. Vice Chair.
Thank you, Mr. Chairman. Commissioner O'Donnell.
Thank you. I have a question for Mr. Duncan and one for Mr. Hamilton. Mr. Duncan, the objection of MCC seemed to be one of the major objections was that all of the information was not put forward initially. And they said the pre-approval statute basically wants all that information front loaded instead of getting it through discovery. So I support the motion, but can you give me your opinion historically in terms of MCC's argument that Northwestern's application did not conform to what was anticipated by the statute?
Mr. Chair, Mr. Vice Chair, Commissioners, I think historically that you're never going to get all of the information that's required in the application. That's just a fact. So yeah, that's why you have discovery. And so the job then becomes, I think, to decide is what they filed, is that adequate? Is that an adequate starting point? And I would add that in their previous filing, when they filed the portfolio of the Laurel gas plant and Beartooth Battery, the information they filed on Beartooth Battery as part of that filing was quite similar to what they filed in this one. And in that particular instance, the commission did find the filing adequate. So it would be sort of a strange thing to say it was adequate then and it isn't adequate now. Part of the reason that staff had made that finding in the previous docket was that we identified essentially some of these same issues that we would want fleshed out. And at that time, our decision was that we could do this and we could do it through discovery. So I don't think our position on that has changed, Mr. Chairman.
Mr. Chairman.
Follow up, Commissioner O'Donnell.
Thank you. Yeah, again, my inclination to resolve things expeditiously runs afoul of procedure. Yeah, I would like for all this information to have been, so to say that the application was insufficient, in my mind, using lay terms, I would say that it is therefore, for the reasons that you said, inadequate or incomplete, okay, but not insufficient. So I will support the motion to get the process moving along. But Mr. Hamilton, given 360 days for us to reach a decision, can you anticipate what would happen to this whole procedure of pre-approval should the lawsuit finding pre-approval to be unconstitutional succeeds? What position does that place us in now?
Mr. Vice Chairman, Commissioner O'Donnell, if the 350 Montana litigation declares the pre-approval statute unconstitutional, that would stop us from continuing on. It is that pre-approval statute that provides the process and the structure for what it is that the Northwestern's application is seeking to accomplish here. So that would be a major impediment to proceeding. The litigation, of course, was filed in relation to the last pre-approval application, which was docket 2021.02.022, which included both the Beartooth Battery and also the Laurel Generating Station. That litigation is still ongoing. We don't yet have an order from the district court in Missoula saying one way or another whether the statute is constitutional. The matter is fully briefed on summary judgment. I do believe we will have a decision on summary judgment soon, but we don't have it yet. And so I hope that answers your question, but before I turn it back over, I'd like to just add a little bit of clarification or gloss on what Gary mentioned just a minute ago. We should anticipate that we will not have all the information that's required to make a final decision presented in the original application. That is why we have the process. What is reasonable for us to expect is that the party will have all the information submitted that is required by our rule that establishes the minimum filing requirements. So while staff has identified 4 additional issues here that we think would be relevant for the commission's final decision, we can't say that those 4 issues are required to be addressed in the original application by our procedural rule. So that's really the distinction in my mind that's important to draw here. When we talk about the information that's required at this stage, it's just to satisfy the minimum filing requirements in our rule, not to satisfy all of the elements that'll be required for the commission's ultimate decision on the application.
Thank you, both of you, for those answers. I appreciate that. Thank you, Mr. Chairman.
Thank you, Commissioner O'Donnell. Commissioner Fielder?
Thank you, Mr. Chairman. I think probably a question for Mr. Hamilton. This is regarding the timeframes. And as I read this, the application was submitted on December 21st, 2021. So does that start the clock on this proposed 360-day timeframe?
Mr. Vice Chairman, Commissioner Fielder, yes.
Okay. That seems like a long time out.
Mr. Vice Chair, I've lost sound. Excuse me for interrupting, but can anyone hear me at this point?
Suffering from an illness. Is he suffering from an illness and didn't want to be in here?
Chairman, can you hear us now? Oh, he was?
Pretty hard to find anybody that hasn't had COVID.
Right.
No, my wife and I haven't had it. One of my daughters and her, my son had it. They were all vaccinated. He just recently had it. No, very mild.
Chairman, can you hear us now?
Mr. Vice Chair, do you want to give a test here?
Testing.
Mr. Chairman, can you hear me?
I can now.
All right. So we then will resume. And Mr. Hamilton, I think you were advising us.
Mr. Chairman, I was asking a question of Mr.
Oh, I'm
Hamilton.
sorry.
So
Commissioner Fielder.
thank you. And this had to do with the time frame. So the staff has recommended front loading the application with additional required information that I think gets us a jump on things to help expedite the process. These are things that we determined that we probably would have wanted to flesh out when the last application was submitted, and we're just front loading those up in this one to move things along quickly, correct?
Mr. Vice Chairman, Commissioner Fielder, because of the withdrawal of the last application, we never really got to the point of additional issues. But yes, our intention here in identifying the issues early is to provide as much advance notice as possible to the parties that these are items that need to be addressed.
Okay, I appreciate that. Follow up, Mr. Chairman.
Follow up, Commissioner Fielder.
So my question goes to this extended deadline that we're asking for, that the staff is recommending right now. The 270 days is the longer of the two available in statute. And then the added 90 days puts us at 360 days. In a time of rapid inflation and supply chain uncertainty, I have concerns about informing a party that it's going to take us 360 days to make a decision. And a lot can change in that time. And I have a real bad gut feeling about, placing that kind of onus on a party. So can you provide some perspective on why those extensions are necessary, and whether we could, whether you were hopeful that this could be expedited well before those actual deadlines?
Mr. Vice Chairman, Commissioner Fielder, the reason why staff recommends the additional 90 days at this stage is because we have a novel application that's requesting for, as I mentioned the first time, a battery storage facility, which has unique capabilities and characteristics that make it different from your typical generation facility, which this commission has previously considered and vetted through prior pre-approval applications. In other words, the commission has experience granting pre-approval and processing applications for traditional generating facilities, but we don't yet have that experience. And most importantly, interveners do not yet have the experience of putting together the testimony and modeling to either rebut or support or make whatever point they would like to make about Northwestern's current application, about this unique battery storage agreement. In terms of the regulatory leg and the impact that can have on the overall project and the prospect of inflation complicating matters in that period of regulatory leg, unfortunately, that there's an element of that is inevitable. But I can at least represent from my perspective that it's never staff's intention to delay these things and increase regulatory leg for the sake of taking more time. It is, if it is possible for the parties, by addressing some of these issues at the earlier stages, by having a longer period of initial discovery with Northwestern and having an opportunity to fully vet the models and simulations and supporting evidence that are included with Northwestern's application, it may happen that we don't need the full 360 days to resolve this application, that the commission could act quicker. However, recognizing that it is novel, recognizing that there may be some important questions of modeling asked by the parties that will require additional time for their own experts to prepare testimony and provide evidence for the commission. I still believe that it is prudent to include the 90-day extension at this juncture. And if you don't mind, Commissioner Fielder and Vice Chairman, I would pass it over to Gary as well, since he has experience with how these complicated dockets have proceeded in the past.
Mr. Duncan.
Mr. Chairman, Commissioner Fielder, I agree with everything that Lucas has said here. I did have some concern at our staff meeting yesterday about what our schedule might do to the actual, construction and operation of Beartooth Battery. But I went back and looked through the testimony, and I'll quote you here. This is from the testimony of Mr. Lefebvre from Northwestern. And what they say is that Northwestern executed the ESA on April 21st, 2021, but they amended the ESA on November 23rd, 2021. So they amended it at the end of November and they filed this in December. And what it says is that the ESA is for a 20-year term, and the guaranteed commercial operation in the ESA is October 1st, 2023. Now, what is the ESA is contingent upon commission of approval of Northwestern's application. And the amendment to the ESA extended the anticipated deadline for commission approval from April 30th, 2022 to November 1st, 2022. So their own application is stating that they fully expected that they would not get a decision until November 1st, 2022. So if we go into December, it's a month and a half, and hopefully we could get it done before then. But then the other provision in their amendment is that Beartooth will proceed with construction of the facility after receiving a notice to proceed from Northwestern, which is going to be based on commission approval. So I was concerned to some extent that our schedule was going to push out Beartooth, to a significant amount. And it appears from this language that it actually really doesn't, that it almost fits into the schedule that was laid out by Northwestern to begin with a month or so difference.
Mr. Chairman, Mr. Duncan, thank you. That was very helpful. Appreciate that. It seems they've anticipated this well, and our timeframes seem to be pretty closely aligned then.
Yeah, it's not their first rodeo either. So.
Is there further discussion of the motion? Commissioner O'Donnell?
Yeah, thank you, Mr. Chairman. I understand the motion is just to accept the application, but given basically a year's period of time or through next December, is that it's already February. Battery technology is increasing, hopefully, at a very rapid pace, and may change greatly. During the process, if we approve the application based upon the information that is available at the time, and then technological advances render a battery facility to be uneconomic, as we've seen with existing coal plants, for instance. Because it's on the pre-approval thing, should that happen, should it become uneconomic and be replaced by something else, would that be the burden of, would that fall entirely on the shoulders of the ratepayer to continue with that obligation? Or would there be any shared burden with shareholders as well as ratepayers?
Mr. Chairman, Commissioner O'Donnell, I have two comments regarding that. First of all, I'm not sure within the ESA itself, we'd have to look what contingencies could lead either party to get out of that contract. I mean, I would assume some quantum leap in technology might lead Northwestern or somebody to want to get out of that, but I don't know what's in the contract. But the other thing I would mention is actually not anticipating your direct question, but just for my own curiosity, I've been reading up a little bit on battery storage technology, and the technology has been growing by leaps and bounds, but it's always been constrained by these lithium ion batteries. So the gains have been made over time. The last few years have been incremental changes. They're saying that the next quantum leap in battery technology is what they're calling a solid state battery, but they don't really expect anything like that to be available for, I think, like to 2030, like 7 to 10 years. So, I mean, I'm no expert in this, but just what I was reading was, it would seem like, what they're proposing here doesn't sound like it's something that's going to be outdated, within the next year or so. That, like I said, the quantum leap in technology is going to be a few years out. But the other thing we would have to do then is look at the ESA and see, what provisions there are for them to get out of that. So
Thank you.
Mr. Vice Chair, this is Chairman Brown.
Chair Brown.
I think we're going so far afield of
Yeah.
my motion that
I
I would like to
Mr.
bring it
Chairman,
back.
I agree. I was simply extending the courtesy to Mr. Duncan to finish his remarks and then was going to move us forward.
Mhm.
Is there further discussion of the motion? Let me just say that I think, especially with regard to extending the timeline here, we should remember that the manner in which we deal with this battery question is something is going to be with us as we move forward. And I think, as I've said before, there are times when it's really important that this commission focus more on getting something right than getting something done fast. And I think this is one of those situations, especially given the observations of Mr. Duncan with regard to the applicant's own timeline and the like. So I don't see that we're doing anything onerous here. And so with that, without further discussion, I would call the question on the motion. All those in favor of the motion signify by saying aye.
I,
Opposed, no. Motion carries unanimously. Mr. Hamilton, Mr. Duncan, thank you very much.
thank you.
Now we'll move on to the final work session of the day, which is commission initiated, and it is a review of the status of ongoing litigation. The presiding officer of any meeting may close the meeting during the time of discussion. The time and discussion relates to a matter of litigation and or litigation strategy, and the presiding officer determines the need to protect agency litigation decision-making and discussion exceeds the public disclosure. The discussion in this closed session will involve discussion of decision-making related to ongoing litigation in which the agency is involved as a party. Accordingly, as presiding officer of this meeting, I am closing the meeting to the public. We will adjourn to the commissioner conference room for that session, and upon completion of that session, this regular meeting of the Public Service Commission will adjourn. Thank you all very much.